I am Jim Jacobson. I practice in estate planning, probate, and trust law at Pickrel, Schaeffer, and Ebeling. I am certified by the State Bar Association in those fields. Today I'm going to talk to you about the non-tax reasons for using a revocable trust as part of your estate plan. Many people have asked me over the years whether they should use revocable trust as part of their estate planning and what are the advantages for them. Many people feel that if they are not wealthy, they should not consider estate planning using revocable trust, but that is not true. Over the years, the estate tax laws have changed substantially, and those factors should be considered when you meet with your experienced estate planning attorney. The final decision will depend upon your finances, your family situation, your personal preferences, and the laws in place at the time. Some of the reasons to use revocable trusts that are not related to tax reasons include, number one, confidentiality and privacy. Most people want to keep their personal finances as well as the terms of their planning in a confidential format. Going through probate will not keep that privacy because that is public record and frequently available through the internet these days. The second benefit of using revocable trust for estate planning involves the efficient management of the assets. So during the lifetime of the individual, if the individual has a health problem, it is an easy transition to have the successor trustee take over, manage the assets, and also pay the bills. It is also very easy upon death to have the successor trustee take over, pay the final bills, and then distribute things according to the family. This is much more efficient than having the standard transfer on death TOD accounts or payable on death POD accounts that many banks and brokerages advise. Also, if you use a revocable trust, another big benefit is it's easy to change. If you want to update in a small or a large way, you just change the revocable trust. You do not need to go around and change multiple beneficiaries. Another benefit is during a second or subsequent marriage situation where you want to provide for the surviving spouse, but you want to make sure that the assets that remain at the death of the surviving spouse go back according to your plan and are not changed. Also, clients in a similar fashion, a benefit for clients that want to protect a substantial inheritance or family gifts. A trust is an excellent vehicle to make certain provisions during the life of a spouse or other people and then have it returned to the planning of the person that sets up the trust. Another benefit of a revocable trust is a limited way of avoiding creditor claims. In Ohio, creditor claims are not allowed against revocable trust in general after death. Another benefit of the revocable trust planning is when you have a statutory claim involving a surviving spouse. In Ohio, a surviving spouse cannot assert the statutory claim against assets in a revocable trust. Those rights only apply to probate assets at this time. Another thing that needs to be considered by clients is that once these revocable trusts are set up, they need to take the next step to title things in the revocable trust name or have the beneficiary change to flow to the revocable trust. I have not discussed any details today, but there are many opportunities for tax planning and tax avoidance using revocable trusts, which should be discussed with your estate planning attorney. There is no one-size-fits-all. Everybody needs to discuss their personal preferences and situation with their estate planning attorney. Ignorance is not bliss in estate planning. You need to plan and take time to plan. Please call the experienced estate planning attorneys at Pickrel, Schaeffer, and Ebeling at the number below. Thank you.